Welcome to 4 Slide HR, and in this today's session we will discuss on the new labor code which has been passed by the Government of India from both the sessions and both the parliaments, their houses, Lok Sabha and Rajya Sabha, and which are ready for implementation from May 1st, 2021. But there is a recent news that it may be postponed for implementation for some time due to some territorial elections. So in this today's session, we are going to learn about the 4 code related to the labor code and labor relation and labor scenario is going to change in India. What is their impact and the benefit and versus for the employee, laborer as well as the principals and the employer. So in this we will cover all 4 labor laws and labor code: the code on wage, code on industry relation, code on social security and code on organization safety and health. Let's come forth with the Occupational Safety, Health and Conditions of Services Code 2020. In this Occupational Safety, Health and Conditions of Service Code 2020, near about 12 and 13, the mandatory acts and law of its existing has been merged with this Occupational Safety, Health and Condition of Services Code 2020. This is the combination of the Factory Act 1948, the Plantation Labor Act 1951, the Mine Act 1952, the Worker, Journalist and other newspaper employment condition of services and miscellaneous provisions Act 1955. The Working Journalists Fixation of Rate of Wages Act 1958, the Motor Transport Workers Act 1961, the Beedi and Cigar Workers Condition of Employment Act 1966, the Contract Labor Regulation and Abolition Act 1970, the Sale Promotion Employees Condition of Services Act 1976, the Interstate Migrant Worker Regulation of Employment and Condition of Services Act 1970, the Dog Worker Safety, Health and Welfare Act 1986, the Cine Worker and Cinema Theatre Worker 1981, the Building and Other Construction Workers BOCW Regulation and Employment and Condition of Service Act 1996 has been included in this Occupational Health, Safety and Condition of Service Code 2021. What are the changes and the authority has given by the central government in this code to the state government and the legislative governments? State government shall be appropriate government in respect of the occupational safety, health and working condition in a factory situation in the state. It is mentioned in the section 2D of this code, means all the authoritative power has been given to the state government in the Occupational Safety, Health and the Working Condition Code 2020. Issuing of appointment letter mandatory by the employer of an establishment included existing establishment within 3 months of the commencement of the code to promote formalization of employment. Section 6(1) of the section subsection F. It means it is mandatory now to, in this code, every person or every employee should have the appointment letter in their organization where they have employed. Then free of cost annual health checkup for employee above the specific age by which it would be possible to detect diseases at any early stages. So it is mandatory that a free of cost annual check has been given and provided by the establishment to their employees. Engagement of contract labor in core activity is prohibited. Code defined what is core activities. We will discuss it later in. On one registration under the code of establishment having 10 or more employees, then the factories with 10 or more workers register in accessory as an establishment. However, the All the provisions of the code are not applicable as per the section 2, 5th and the 3rd of this code. For factories with 20 workers with power and factory worker without power, all provisions of the code are applicable, including restoration. No worker shall be required to allowed to work in any establishment or class of establishment for more than 8 hours in a day. Every worker employed in establishment shall be entitled to leave in a calendar year with wage, subject to the condition that he has worked 180 days or more in such establishment more than 240 days. Now it has been fixed for the 180 days. Here it need to be clear that they have to work physically and the present physically in the work days. Worker will be able to get more leave carryover restricted to the 30 days, but provision made for encashment of leave in excess of 30 days has been now. No lapse of leave can be encashed every year. If there is a lapse of leave encashment can be encashed every year, means the earlier there are the provision of the lapse of the leave like SL and CL that will be encashed for every year. Now the code enable employment of women in all establishments for all types of work, included work at night beyond 7 p.m. and before 6 a.m. subject to the condition relating to the safety, holiday, working hours and their consent is required. So now the female worker can work in the organization with the night shift to beyond 7 p.m. before 6 a.m. condition also based on some conditions. Then the contract labor provision relating to the contract labor will apply to establishment employing 50 or more contract workers and to every manpower supply contractor employing more than 50 workmen. Section 45. Contractor engaging contract worker in more than one state can obtain a common license from the designated authority. There is the provision of the common license from the designated authority if a contractor is working in the multi-states. Welfare facility for the contract labor to be provided by the principal employer. It is same as earlier it was mentioned in the Factories Act or the Contract Act. Interstate migrant worker. The interstate migrant worker means a person who is employed in an establishment and who has been recruited directly by the employer or indirectly through contractor in one state for employment in such establishment situated in another state, or the subsection 2 has come to his own from one state and obtained employment in establishment of another state, hereafter called destination state, or has subsequently changed the establishment within the destination state under an agreement or other arrangement for such employment and draws wages not exceeded the amount of rupees 18,000 per month. Provisions of interstate migrant workers applicable to the establishment which 10 or more migrant workers are employed or were employed on a day of the preceding 12 months, and medical checkup facilities, ESICs, PF benefit are to be provided in interstate workmen too. But one thing which have to remember here, that is their wage ceiling amount, who will be considered as interstate migrant worker whose wage drawn is not exceeded than the rupees 18,000 per month. And in case of a public emergency or disaster or pandemic in whole of India or part thereof, the appropriate government may by notification exempt any workplace or work activity or class therefore from all of any of the provision of this code for such period and subject to such condition as it may think fit. Then the wages mean all remuneration, whether by way of salary, allowances and otherwise, expressed in term of money or capable of being so expressed, which would, if the term of employment expressed or implied were fulfilled, be payable to a person employed in respect of his employment or a work done in such employment, and included basic pay, dearness allowances and retaining allowances. It is as existing, but there is the changes. The basic pay has been changed. We will discuss that in later on in detail, but it does not include any bonus payable under any law for the time being in force, which does not form part of the remuneration payable under the terms of employment. Then the second part of the not included, the value of any house accommodation or of the supply of light, water, medical attendance or other amenities, or of any services excluded from the computation of the wages by a wage means all remuneration, whether by wage of salary, allowance and otherwise expressed in the term of money and capable of being so expressed. That has been included the three parts: basic pay, dearness allowance and retaining allowance if any, but does not include any bonuses payable under any law, and then the value of accommodation of housing and additional facilities provided by the employer. Now then go to another part, the contribution paid by the employer to any pension or provident fund will also not included in the wage. Any conveyance allowance of the value of any travelling concession will also not include, and any sum paid to the employed person to defray special expenses entailed on him by the nature of his employment, mean any expenses for the travelling and work done for the establishment. House rent allowances will not as the part of the wage. And then remuneration payable under any award or settlement between the parties and order of court or tribunal, that will not include the wages. Any overtime allowances, any commission payable to the employee, any guarantee payable on the termination of employment, and any retrenchment compensation or other retirement benefit payable to the employee, or any ex gratia payment made to him on the termination of the employment, that does not include in the wages as per this new wage on code and the labor code. Then provided that for calculating the wage under this clause, if payment made by the employer to the employee under clause A to 1 exceed 1/2 or such other percent as may be notified by the central government of the all remuneration calculated under this clause, the amount which exceeds such 1/2 or the percent so notified shall be deemed as remuneration. So this is all about in this session today, and see you in the next session in the explanation of varied with these new labor codes. Be connected with us and sign up and connect, subscribe this 4-slide HR for this advancing knowledge on the labor laws and your HR system. We are making and building here the new paradigm of the HRM in this unpleasant time.